everyone, and welcome. On behalf of the Kappa Psi Alumni Association, I'd like to welcome you to the June edition of BOHTalks. The talk I'll be giving today is on estate planning, the four asterisk most important documents of your life. I'll be your presenter today. My name is Hunter Moreland. I am a life member of the Kappa Mu chapter at the University of Georgia, and I'm currently an estate planning and tax attorney here in Atlanta, Georgia. I'm just going to start off with a couple of disclaimers here. Content that I present to you today should not be considered legal advice. I would recommend that you seek out personal counsel in your state of residence or any specifics pertaining to your situation. I'm an attorney licensed in Georgia, so I can only speak specifically about how Georgia handles the laws around estate planning, but I can give you a very general idea of how other states handle these topics. Now, one other disclaimer I'd like to give is regarding the content of what we're going to be talking about today. When you get into conversations about estate planning, there's no easy way around the fact that you'll be talking about death and incapacity. And I completely understand if some of you may not be in a good position to be talking about these topics. If so, you're more than welcome to close out of this video at this point, and I'd like to thank you for joining me to this point. Feel free to revisit this video at some point in the future when you're able to view the content. If you'd also like to talk about this content in a different manner, you're more than welcome to reach out to me, and I'll be happy to facilitate that with you. So now that we've gotten through the disclaimers, let's talk about what is estate planning. At its core basis, estate planning is setting up a comprehensive plan for the management of your assets once you are unable to manage them yourself, be that by incapacity or your passing. Now, you may be thinking, oh goodness, my assets, I don't even have anything. I have a negative net worth at this point. Well, that's perfectly fine. What I want to stress to you is estate planning is for everyone. You know, even having a very simple, basic plan once you turn 18 is better than having nothing. A lot of states are going to have a method for handling your affairs once you hit the age of majority, but that might not necessarily be what you want to have happen with your personal affairs. So even just that basic, bare bones plan will oftentimes be better than what your state of residence has in place for you. The other thing that I'll talk about with estate planning here is always, always, always go with attorney drafted documents. AI is just not there yet. Now, I know that'll sound like a sales pitch, but in my years of practice, I've seen many issues show up when you get to services like the freewillandtrust.com or LegalZoom, or even some chat GPT documents I've seen come through. They're just not there yet. And these services that give you a form to fill out the questions, it's not going to address all of the circumstance around why you may be doing estate planning. Now, there's a famous quote out there between Charles Babbage and a member of Parliament, Charles Babbage being one of the founding fathers of modern computers. The member of Parliament asked Mr. Babbage, basically, if you put the wrong numbers into a calculation, can you still get a computer to spit out the right answer? Now, of course, you and I both know that that's a ludicrous statement. That's not possible. But unfortunately, that's where AI is currently with estate planning documents. An attorney is going to be able to suss out those things that you might not even be thinking about. So always, always go with attorney drafted documents. So I've talked about getting those documents. What are the documents? Well, the four asterisk most important documents of your life as it pertains to estate planning are going to be a last will and testament, a designation of healthcare surrogate, a living will, and a financial power of attorney. Now, these four documents can be broken into two categories: the documents that are effective during your life, documents that are effective upon your passing. So we'll start with the documents that are effective during your life. First of these is going to be that designation of healthcare surrogate. What this document is going to do is allow you to designate an individual to make medical decisions on your behalf in the event that you cannot make those decisions for yourself. While you're still in control, while you're still all there, you're going to be the one calling the shots. This would only come into effect after that point where you can no longer make those decisions for yourself. This document, in a lot of circumstances, will also allow you to make some proactive decisions about your own medical care. And some of these forms will also allow you to make some proactive decisions about final disposition of your body and donation of organs. As a corollary to this document, we'll get into the next document, a living will. This living will is going to either allow you to designate someone to make the decision for your end of life care, or allow you to designate what that type of care would be, whether that be extending your life as long as possible using whatever means of medical science is available, or allowing your natural death to occur, not receiving any machine intervention, or some hybrid approach between the two of those. Now, you may notice throughout this presentation, I've given a little asterisk on the 4 documents. Well, that's because in some states, Georgia being one of them, some states have merged the concept of that designation of healthcare surrogate and living will into one document, which we call an advanced directive for healthcare. So you may only have in your state 3 important documents for your life. So your mileage may vary. The last document effective during your life is going to be a financial power of attorney. This financial power of attorney is a document that, similar to the designation of healthcare surrogate, is going to allow an individual to make financial decisions in the event that you are unable to. Now, I see a lot of flexibility with financial powers of attorney on when they are effective. Sometimes they'll be effective immediately upon signing, and sometimes they'll be effective only upon incapacity. There's some benefits to either option. If it comes into effect immediately, I use the example of my father and my grandmother, where my father's the power of attorney for my grandmother, and sometimes she needs some help handling her finances. She's 88 years old, about to be 89, and she's a little more feeble than she used to be. So my dad helps her out. The other option, of course, is having it become effective upon incapacity, and that just helps when an individual is, say, a ward in a care facility and someone needs to be feet on the ground handling their financial situation to make sure that they still have assets to continue to live in their current standard. So those are going to be the documents that are effective during your life. Now we'll go over to documents that are effective upon your passing. There's only one real document here. It's going to be the last will and testament. Now, I've seen a lot of people get the lines blurred with a financial power of attorney and the last will and testament. Power of attorney does not equal a personal representative. So just remember that financial power of attorney, designation of healthcare surrogate, living will, that's all during your life. Once you pass, those documents are done. We're just looking at the last will and testament at this point. What that last will and testament is going to do is provide a framework for distribution of assets upon your passing through the probate process. Now, the probate process is run through the probate court or chancery court, or a lot of other states have different terminology for that, but it's the formal process of a nominated personal representative taking your original will, presenting it to the court, and allowing the court to appoint you to wrap up the final affairs of deceased individual. Now, wrapping up those final affairs could include payment of final creditors, payment of final income taxes, and ultimately distribution of assets pursuant to the directions that the deceased individual has left in their last will and testament. There's a lot of provisions that can go into a last will and testament, but as I said before, even having a basic last will and testament once you turn 18 is oftentimes going to be better than having nothing in place. I'll talk a little bit right now about the intricacies of the distribution of the assets and the probate process. Now, probate, depending on what state you live in, can be pretty tricky. Georgia has a very simple probate process, but I know other states, your New York's, Florida's, Texas, California, those kinds of states can have a very onerous probate process. So some people may want to avoid the probate process by execution of additional documents or titling the assets in a certain way. And that may be a good option for you, but just know that it may not be the best option. There's a lot of considerations to have, including the taxability of those certain assets. So again, consult an attorney. They can assist you with this process. I'll give a quick little aside at this point to the concept of trusts. Now, trusts are a very popular tool for estate planning, but they're not for everyone. Everyone in the media will tell you, you need this trust. It's what the celebrities have. Oh my gosh, how are you ever going to get by without having a trust? They're not entirely correct. Trusts are good for certain situations. Say, you need to do some complex tax planning, or you have property that lies out of your state of residence, or you got a weird family situation going on, or you just don't want your assets in the public view. Probate is a public process. A trust may be good for you. But trusts are only as good as you are willing to do your homework. If you're not willing to go through and make sure that all of your assets are titled in the name of a trust, there's that one Weasley little item that's hanging out there on the side. That asset may have to go through the probate process or be abandoned. I don't know about you, but I want my family to hang on to those assets that I've worked hard to get. So I've kind of gone over the high level, what are the basics of estate planning, what are the documents that you need. So I'll go ahead and tell you a horror story, so to speak, of what happens when you wait too long to do your estate plan. I'll tell you the story of Doug. Doug was a client that I had the opportunity to work with around this time last year. Doug was described by his singular friend as not a very nice person. Doug managed to push away all of his family, all of his friends, and wouldn't you know it, he managed to outlive all of them too. Doug so desperately wanted to give everything to his one and only friend, but due to Doug's declining health, we were unable to accomplish this. When the friend reached out to me, Doug was already in a declining situation, and he was in a care facility. And so we tried to meet him bedside to execute some documents, but unfortunately, Doug's condition had declined to the point where we did not feel comfortable that he had the mental capacity to sign any sort of documents. So then we tried to go in a roundabout way to get control of some of these assets just so that they could be managed for his care through a guardianship and conservatorship, with that friend serving as the guardian conservator. Well, due to delays with the court, we made it about halfway through that process before Doug unfortunately passed away. So now we're trying to distribute assets to Doug's only friend and who he wanted the assets to go to. But because of the laws of Georgia, we had to distribute the assets to his heirs at law, which this friend, not being an heir at law, not being related to him, the assets had to be distributed to some third cousins halfway across the country. Not what he would have wanted. And the last thing that's just truly heartbreaking about Doug's story is we so desperately wanted to get Doug buried with his family. But because there was so much hassle getting in contact with these third cousins who didn't even know about Doug, just from a family Bible seeing his name, and trying to work with their attorneys and the court and all the intricacies of that. Well, Doug's body was sitting in the morgue, the hospital, and after a couple of months, the body began to decay, and the body later had to be removed from the hospital, and Doug was buried in a pauper's grave on the other side of town, which we don't even know exactly where he is. Absolutely horrifying situation. So all of this, I'll leave you with another quote by Chaucer: "Time and tide wait for no man." Doug waited too long to get his affairs in order, and I told you what happened to him. You don't want to be in the same situation as Doug, so go ahead, reach out to an attorney, get your affairs in order, even if it's just something basic that you don't revisit until 10, 20, 30 years down the line. Having something in place is going to be considerably better than having nothing in place. Thank you for joining me here today. Again, my name is Hunter Moreland. I'm an estate planning attorney here in Atlanta, Georgia. I'm more than happy to talk with any of you here in the future if you have some additional questions about estate planning, or looking for resources on estate planning, what may be some of the best topics for you to investigate. I'll recommend that you reach out to your state's bar association, see if you are looking to get some documents prepared, and they can direct you towards a local attorney who does practice estate planning. Make sure you get with one that does practice estate planning and not a general practitioner. Trust me, I've seen some issues with that too. So if you have any questions, feel free to reach out, and I'd like to thank you for joining me here today. Have a wonderful rest of your day.